At some point, usually after a big life change like getting married or having a child, most people have the same thought. I should probably get a will or maybe a trust. Actually, I don't really know which one I need. And then they Google it, get confused, and do nothing. Or they pay an attorney, sign some documents, and assume they are covered without really understanding what they just signed. This video is for those people. By the end of it, you will know exactly what a will does, what a trust does, and which one actually controls each asset you own, and what most people get wrong about both, including people who already have both documents sitting in a folder somewhere. Because here's the thing, having a will does not mean that your estate is covered, and having a trust does not either. What matters is understanding which mechanism controls each asset you own, and that's what nobody actually explains. Let's fix that. The question that most people ask is, do I need a will or a trust? That's actually the wrong question. The right question is, for each asset I own, what mechanism controls where it goes? Because the answer isn't always your will, and it isn't always your trust. In many cases, it's a form you filled out 15 years ago and never thought about again. By the end of this video, you'll have a clear mental model for how your assets actually transfer, what a will does and what it doesn't, what a trust does and where it falls short, what these documents actually cost, and a practical checklist to identify where you may have real gaps. This isn't basic estate planning 101. This is an actual conversation that we have with executives who have already done the basics, but want to know how their real-world setup will actually hold up. Let me give you a simple mental model. I call it the asset control stack. Every asset you own moves at death through one of three mechanisms. If you own property jointly with your spouse with right of survivorship, it passes to them automatically. Same with brokerage accounts that carry a transfer on death registration. The third, and only the third, is the court process called probate. Probate captures what's left. Assets in your name alone, with no beneficiary designation, no transfer on death, and not in a trust. Here's why this matters for you specifically. As a high earner, a significant portion of your net worth likely lives in the first two buckets: retirement accounts, life insurance, jointly held real estate, brokerage accounts with TOD designations. Your will only governs what ends up in the third bucket, and a revocable trust only governs assets that you've actually moved into it. So the real estate planning question isn't which document do I have, it's which mechanism controls each asset that I own. Now, before we go any further, if you're already thinking, I need to look at my actual setup, well, that's exactly the conversation that a wealth strategy call is built for. It's a no-pressure working situation where we look at your real accounts, your beneficiary designations, your titling, and help you to identify where things may be misaligned. And if you're already a comprehensive wealth management client of ours, this coordination, along with the document filing, is already included in your plan. The link to schedule the call is in the description. Now, let's keep moving. Now, let me be precise about what a will actually does. A will controls your probate assets, the ones that end up in that third bucket. It names an executor who manages your estate through the court process. It can nominate a guardian for your minor children, which is actually one of the most important functions of a will and one that is often overlooked. For most people, a straightforward attorney-drafted will runs somewhere between $750 to $1,500, depending on complexity and where you live. It's a relatively simple process, and there's no good reason not to have one. But here's where the will stops. A will has no authority over assets that transfer by beneficiary designation or by title. None. Let me give you a scenario that's more common than people realize. A 44-year-old CFO updates his will after his second marriage. He leaves everything to his second wife. His documents are clean, his attorney signed off on it, he feels good about it. What he didn't update is the beneficiary form on his 401k from 11 years ago. That still names his ex-wife. When he dies, the retirement account, potentially a seven-figure account, goes directly to the ex-spouse. His will is completely irrelevant for that asset. The beneficiary form wins every time. Here's another one. Life insurance payable directly to a minor child. The intention is protective. The outcome could be a court-appointed guardianship that manages the money until the child turns 18. And when they do, they could receive a potentially large sum of money with no guardrails whatsoever. Your will, no matter how well written, cannot override the contracts that are already in place. Now let's talk about trusts, and specifically revocable living trusts, which is what most people mean when they say, I have a trust. A revocable living trust controls assets that are actually titled into it. For those assets, it can bypass probate and make for a much smoother, more private transfer to your beneficiaries. But here's where a trust does something a will fundamentally cannot. It can authorize a successor trustee to manage your affairs if you become incapacitated. Think about that for a second. A serious health event, a stroke, a prolonged illness, a car accident is an estate planning event while you're still alive. Who can access your accounts? Who can pay your bills, manage your investments, make decisions on your behalf? A funded revocable trust answers that question without requiring the court to appoint someone. That alone makes the trust conversation worth having for most executives. Now, what does a trust actually cost? A complete revocable living trust package, including the trust document itself, a pour-over will, powers of attorney, and healthcare directives, typically runs between $2,000 and $5,000 with an estate attorney. More complex situations, like those with blended families, multi-state real estate, business interests, or larger estates, can run $10,000 and up. And that's not an unreasonable number for what it does. Because I'd also tell you that the cost of doing nothing or doing it wrong can be dramatically higher. Multi-state probate alone can run tens of thousands of dollars in legal fees and take years to resolve. Now, a few misconceptions to clean up directly. The first, I have a trust, so I'm covered. A trust is a container, not a magnet. It does not pull in your assets automatically. You have to fund it, meaning you retitle your accounts and your real estate into the trust's name. I've seen executives pay $5,000 to have a complete trust package drafted, sign the paperwork, file it away, and never move a single account into the trust. The trust exists on paper. In practice, it doesn't control much of anything. The second misconception is that a revocable trust is a tax shelter. The IRS treats assets in a revocable trust as still belonging to you for estate tax purposes. If you're hearing otherwise, ask more questions. Now, let me give you a practical framework for thinking through your own situation. I'd organize your assets into 4 categories. Category 1, contract assets. These are your 401k, IRA, Roth, HSA, life insurance, annuities. Hold the beneficiary designations on every single one. Not from memory, from the actual form on file with the plan administrator. Category 2, title-driven assets, your primary residence and any other real estate. Brokerage accounts, check whether they carry a transfer on death registration. Joint accounts and business interests. For each one, how is it titled and does that match your current intentions? Category 3, probate assets, anything in your name alone with no beneficiary, no transfer on death, and not in a trust. These are what your will actually controls. Category 4, specific to executives, these are what I call your corporate paperwork assets. Your RSUs and stock options are governed by your employer's plan documents and your beneficiary designations on file with HR. Not your will, not your trust. Those require a specific conversation with your HR or plan administrator. And if you have business interests, your operating agreement or buy-sell agreement matter enormously for what happens to that ownership stake. Running a quick audit across these 4 categories will tell you more about the health of your estate plan than reading any document that your attorney prepared. So when does a will, combined with disciplined beneficiary titling, actually hold up? And when does a trust become worth the additional cost and complexity? A well-structured will, along with clean beneficiary designations and proper titling, may be enough when your family situation is fairly straightforward. Most of your assets already have clear beneficiaries or transfer of death designations. You own property in one state, and your powers of attorney and healthcare directives are in place. A revocable trust becomes more compelling when you own real estate in multiple states. Without it, you're looking at probate in multiple jurisdictions, and legal costs there will dwarf the cost of a trust. When you have a blended family or complex distribution goals that a beneficiary form can't capture. When you want structure around how and when your kids inherit rather than a lump sum at age 18. And when an incapacity scenario, a health event that leaves you alive but unable to manage your affairs, is something you want a clear, court-free answer to. For most executives, this isn't a binary choice. It's a layered system. The right documents, the right beneficiaries, the right titling, all working together and maintained over time. It's not a one-time exercise. Every major life event, a new job, a child, a divorce, a major equity event, is a reason to look at this again. For most executives, the biggest estate planning gaps are not in the documents. They are in the beneficiary forms nobody has looked at in years, the trust that was drafted and never funded, and the accounts that are titled in ways that made sense a decade ago, but do not reflect where your life is at today. If you want to sit down and map this out for your situation, your accounts, your beneficiaries, your titling, that is what our wealth strategy call is for. It's a working session, not a pitch. We look at what you actually have and help you to identify where the gaps are. The link is in the description. Book it before the next life event makes this more complicated than it needs to be.